Hello and welcome to Let the Record Show. I'm Todd Sivia, your host and partner in navigating life's transitions. At Sivia Law, we believe that every transition in life deserves careful consideration and planning. And that's exactly what we're here to help you with. In each of our radio broadcasts, we tackle important topics that impact your life, your family, and your future. From estate planning to real estate, from business succession to elder law, we aim to provide you with valuable insights and expert advice. We're going to explore a diverse range of topics, invite expert guests to share their insights and wisdom. Our mission is to empower you with the knowledge and resources that you need to make well-informed decisions, no matter what the stage of life you're in. So let me get into the lawyer disclaimer section. So let me remind you that the information shared during this show is for general education purposes only and should not be considered legal advice. Every situation is unique, and we always recommend consulting with qualified professionals to address your specific circumstances. And just remember that the choice of a lawyer is an important decision and should not be based upon any kind of advertisement. So today we're going to dive into the issues relating to beneficiaries. This is a topic that I deal with on a regular basis, and it's impactful to you and how it relates to your life. As we embark on this journey together, I encourage you to stay engaged, take notes if needed, and should you have any questions or thoughts about this show, feel free to reach out to us by calling us at 618-217-1400. Again, it's 618-217-1400. Or you can email us at radio@civialaw.com. And that is radio at SI, V as in Victor, IA law.com. Thank you again for joining us, and we're committed to being your trusted resource as we navigate these intricacies of life's transitions. Sit back, relax, and let's explore beneficiaries together. Let the record show that we're here to guide you in every step of the way. So let's talk about beneficiaries. Beneficiaries, a lot of people use beneficiaries on everything, and, banking institutions, financial institutions, they all ask you what your beneficiary is going to be. This is very, very important. 2 episodes ago, we talked about wills, and beneficiaries are one of the ways that a person can avoid probate by using beneficiaries. So a lot of people make sure that you have beneficiaries. So your banking institutions, your financial institutions, people that handle your IRAs and the like will all talk to you about beneficiaries, and make sure that you've got some kind of beneficiary set up for your accounts, which is great. That's a good rule of thumb, and it's a good catch-all. But beneficiaries are not for everyone. There's also beneficiary deeds that people use. And so in Missouri and Illinois, Illinois just started allowing you to have transfer on death instruments for your real estate. And those are positives. And there's some negatives as well. You can't use it for, like farmland and commercial properties and things of that sort. But you can use it for your personal residence. So you can throw a beneficiary on it. You name your wife or you name your kids as beneficiaries. But there's a lot of common mistakes and lots of common problems that happen when you have this issue that pops up. So what if that person dies? And what are the rules to the game when that person dies? If you have a beneficiary and the beneficiary passes away, do you have your beneficiary set up correctly? And there's a term called per stirpes. And basically what that means is if that beneficiary were to pass away, then their children may be able to inherit instead of that individual. So you've got Tom and Anna as your beneficiaries. Tom and Anna are both of your kids. Tom passes away. Tom has a couple kids, and so you've got some grandkids. So what happens? Well, if you don't have Persterpes language on your beneficiaries, um, then Anna inherits the whole amount as the beneficiary. So, say you have $100,000, and you originally wanted Tom and Anna to receive one half of that interest. Tom dies, Anna's there. The question is, where does the money go? Well, it all is based upon your beneficiary designations and what language is on there. If there's no Persterpes language, it goes all to Anna because Tom has passed away. So, depending upon those circumstances, that's an issue that could be a possible issue. If you're okay with the grandkids not receiving anything, so say you've got Johnny and um, Maria as your grandkids that were beneficiaries of Tom's, or Tom's kids. Unfortunately, those two children do not inherit unless you've got those language. So, what if you do have that language in your beneficiaries? In that scenario, what if Maria is a minor and Tom has passed, Maria is a minor? What happens to the fund? Well, again, now you've got some more issues. So if you have a minor receives the funds, then that minor, if the proceeds are more than $50,000, then we have to set up a guardianship. So if we have to set up a guardianship, well, now instead of going through probate, which it avoided, which is a positive, but now you've got to deal with a guardianship, and there's a fight over who gets to control those funds, and so there's issues with regards to minors, and those minor children, they get those proceeds at age 18. So at any point in time after they turn age 18, they are allowed to receive all those proceeds. I don't know what your children are like, or your grandchildren are like, or your great grandchildren are like. Sometimes we don't know how they're going to act, because maybe they're 2 years old. Maybe they are 10 years old, and you're really not able to judge how responsible that child is when you pass on. But you've passed on, and you have no control over how those proceeds are dealt with. So, we've got that issue. Then, what if they are special needs? If any of the individuals are special needs or become special needs, what happens? So if you have somebody with Down syndrome or cerebral palsy or traumatic brain injury or anything along those lines, if that individual were to receive those funds, there's spend down requirements. So, again, Tom passes away. You have somebody that is one of the grandchildren receives those funds. It's $50,000, and as of age 18, they receive those funds. Well, now, if it's a disabled individual, they have to spend those funds down and get those funds down to $2,000 before they are able to qualify for certain benefits. And that's a pretty hefty toll. That you've worked say you worked your life building up your nest egg, and this nest egg has been building and building, and you've done a fantastic job. Maybe it's instead of $50,000, it is more like $500,000. And you built that nest egg up, and it's now at a point where that $50,000, or it's $500,000, and that child who's special needs, or maybe they're a minor, they get that $500,000. Or if it's special needs, they've got to spend all that money down to $2,000 before they qualify for benefits. Well, that's not how you really want to set it up. But it's so commonplace that banks and financial institutions don't talk to you about what ifs happen, and how do we resolve these issues. But um, but they're important issues. So you've got minors, you got special needs. If you know about it ahead of time, yeah, there's preparation that can happen. But what happens in special needs? People that are born with cerebral palsy and you know certain a traumatic brain injury or something along those lines, you would most people will know and try to avoid that scenario. But this is a statistic: 1 in 4 individuals. So it's 1 in 4. So 25% of all Americans will have a debilitating event in the next 10 years. So 25% of all Americans are going to have some kind of issue that's going to debilitate them, whether it's somebody that's in construction and they throw their back out. Maybe it's a car accident. Maybe it is they have a stroke. Maybe they have some kind of cancer or some kind of event in which they can't work, and they have to go through some type of training or some kind of rehabilitation to get them back to square one, and they have to go on Medicaid, or they have to go on to some program, and they received all these funds. If that's the case, there is definitely some negatives to that, and we don't want that to happen. Once a person passes away, there's not a lot that we can do with regards to planning. So we can't do post planning to avoid those situations. Or, I mean, we can, but it's very, very difficult and very, very costly to do so. We can do some preparation to avoid those issues. I've had clients that have come in to talk to me and say, Todd, I know I'm going to change the beneficiaries if something happens. I know I'll have everything set up so that there's no issues. But the problem is we don't know if we can change it or if we will have time to change it. What if you were planning to go in to make that change, and then you have a heart attack, or you have a stroke, or you have a debilitating event? Or maybe you're in the same event as the beneficiary. So, somebody is transporting you to the hospital, and they get in a car accident, and you're in an event, and they're in an event, and you don't have time. And let's be logical here. I see people probably once every 10 years to have their wills reviewed or their estates reviewed, because most people don't have time. Most people don't want to take the time to look at this issue or update their estate plan. Lots happen. Some people have gotten divorced. People have gotten had new kids, or this issue happened or that issue happened. But they don't take the time to resolve these issues. It's commonplace. I mean, most people don't even have a will. Most people don't even have a power of attorney. Power of attorneys are important issues, but 80% of the U.S. population don't have even that power of attorneys, which is the basic of the basic documents. But we want to rely upon our beneficiary designations to resolve issues. Those are definitely important issues, with regards to beneficiaries. But, what about black sheep? We all have that black sheep in the family, that person that may not be responsible with money. And we've got to decide on how to handle that person. Using beneficiary designations really doesn't help. So I just want to stop here. If you guys, and I've kind of been talking, if you've got questions about beneficiaries, don't hesitate to call us, and we'll see if we can't get you live on the air to ask your questions. So if you want to call us at 618-217-1400, again, it's 618-217-1400, and we can talk to you and kind of sort through these issues with regards to beneficiaries. If you don't want to get on the air, you're welcome to send us an email at radio@civialaw.com. It's radio at SIV as in Victor, IA law.com. So, don't hesitate to call us. But we're still talking about those beneficiaries. What are the issues with those? We've talked about, the minors. We talked about special needs. We've talked about black sheep. Here's another issue. And, I saw this with a client. The client had 3 CDs, and they set it up, and they put pretty much the exact amount within that CD. So they put $10,000 in one CD and $10,000 in another CDs, and then put another $10,000 in another CD. And they named their beneficiary. So they named their beneficiary they set the CD up for Sue. Then they had one for Anna, and then they had one for Charlie. So in these 3 CDs, it was 3 separate CDs. And each one of those CDs earned interest. But they didn't necessarily come up at the same point in time. So one CD came up in 6 months, the other one came up in 90 days, another one came up 2 years from now. And they all earned interest, but they were all different interest. At the time of death, I had this individual. One had, I don't know, it was like $70,000. Another one had $80,000. Another one had $50,000. Came out, put the money in about the same time, and it was equal amounts, but had designated individual beneficiaries. So, one for each child. Well, if each child looked at this amount of money, the one that got $50,000 and the one that got $90,000 and the one that got $80,000, what do you think they felt like? Was it an equal distribution? No, it was not an equal distribution. So designating one individual for these items really put the family at angst at one another, because they were not equal. They were not treated equal. They invested the same amount of money, but the return was not equal. And because of that, there was infighting, and there was true infighting within the family, because it was not equal. And you'd be amazed at what people fight about. But one of the common fights is at the time of death. Whether we prepare our family or not, but it becomes a fight. And one of the family members wanted them to equally divide it. So put it in a pot and divide by 3. Well, that would have been the best way to do it. But that's not how the beneficiaries were set up. Here's another one. Checking account. Somebody designated somebody as a beneficiary for on a checking account, or name them as a signer, as owner, co-owner of a checking account. And what happened? Decedent died, which allowed, the signer was great, gave the person the ability to put their name on and continue to write checks after the person passed away, and paid for the funeral, handled a lot of the end of life transactions. But what obligation did that person have at the end of it? One, to continue to pay the bills. There was none. Same thing with the obligation to distribute to equally between the family members. There was no obligation. There may be a moral obligation, but legally, there is no legal obligation whatsoever for anyone to share these things. I hear clients say, "Well, I'm going to come back and haunt them." Um, I wish that, there's no guarantee with that. We definitely get into the spiritualness of that claim. But, there is no legal requirement to share those funds with everybody. And I always like to share, we're always, when we're dealing with estate planning, we're always dealing with the moral obligation, but also the legal consequences or legal obligation to it. And moral, it's like most lawyers, there's always problems with what the law says. And the law says, even though there may be a moral obligation, there is no legal obligation to share those funds, and that's important for us to deal with. So, people may morally share it, but there's no legal obligation. And same thing with any kind of beneficiary designation. If there is no legal obligation to do so, then there is an impact to that. So what if you don't have a beneficiary on your estate? What happens? So what happens if you said, I'm not going to have beneficiaries in anything? Well, what happens? What happens goes back to the estate. Yes. So if you have a will, then it goes back to your estate, and you follow what your will says. If you have a trust, it's a whole different story. If everything is owned by the trust, everything is distributed, and your beneficiaries change based upon all the different circumstances. So, trusts are usually the better mechanism to do things versus beneficiaries, because if life changes and a minor receives it, special needs person receives it, or dealing with that black sheep in the family, typically a trust will handle it. But if you have no beneficiary, no trust, then it goes back to your estate. And depending upon how much money is in the estate, or how much money flows back into through the estate, that money, if it's over $100,000 in the state of Illinois, or if it's $25,000 in the state of Missouri, then those have to go through probate. And if you want to turn back or listen to this radio program, you're always welcome to listen to it. We do record this, and playback is 100% available, and you can go and listen to it on Advantage News, to their website, and look for podcasts, and look at Let the Record Show, and you'll be able to find all the episodes. But episode 1 really talks about that issue and what happens if you don't have a will and all the rules to that issue. So, but before we go any further, I've got to stop and talk about our sponsors. And we want to express our gratitude to, a lot of our incredible sponsors who make Let the Record Show possible. They support our mission of guiding you through life's transitions. Today, we'd like to thank Bridges Home Realty and Keystone Place at Magnolia Commons for their unwavering support. Bridges Home Realty is your go-to destination for a seamless, integrated home buying experience. It's in August. Christmas is right around the corner. If you're trying to get your house up for sale before the winter time, you need to call Bridges Home Realty. They specialize in buying and selling single-family homes. They help people with rental properties, and they offer expert senior living placement assistance. For more information on Bridges Home Realty, you can visit bridgeshomerealty.com or call 618 979 3602. Again, 618 979 3602. And say hi to Sarah Holscher, one of the realtors with Bridges Home Realty. She is a sweet gal. If you're looking for senior placement or you need help listing your home, she is fantastic and phenomenal person, but also a fantastic realtor. So give her a call, and she'll help you through that transition in life. We also want to extend our appreciation to Keystone Place at Magnolia Commons. They're a retirement living community that is changing perceptions of what retirement community is. Keystone's communities are designed to invoke the feeling of home, providing compassionate support, comfort, privacy, and they've got 40 locations all across the country. Keystone Senior Living is committed to improving lives of their cherished residents. To learn more about Keystone Place at Magnolia Commons, call 618 685 2259. Again, it's 618 685 2259. To our sponsors, we thank them for their continued commitment and making a positive impact on the lives of our listeners and our community. Their support and your support of them helps us to continue to bring valuable insights and expert advice to help you through and navigate through life's transitions. So, when we left off, we were talking about beneficiaries. And, with these beneficiaries, there's one specific topic and one specific group of items that are really, really difficult to deal with. And that's IRAs. And IRA is your individual retirement account. So you can have those IRAs, either it's a rollover from a 401k. It could be a 403b. It could be a thrift savings plan. It could be any type of individual retirement account. And a lot of these, there's also Roth IRAs as well. I don't want to forget about Roths. And we'll talk about, the benefits of Roth here in a second. But with individual retirement accounts, these are very, very difficult because we need to know what happens with an IRA. So let's talk, let's separate IRAs versus everything else. So IRAs, everything else, your bank accounts, your life insurance policies, your annuities, there are some IRA annuities, but your checking, your savings, your money markets, and things of that sort. A lot of those issues are non-taxable. Like, when you pull money out or when you receive that money or, you deal with that money, there's no tax implications associated with it. And say and maybe you invested in stocks, bonds, and mutual funds, and you have an account that handles stocks, bonds, and mutual funds, but it's not this IRA business. It's not a Roth. It's not this rollover 401k. It's regular stocks, bonds, and mutual funds. Say you started investing in this account. You had $100,000, and now you've really invested over the years, and you've had some great returns, and you've built that up into, say, $500,000, and you really haven't touched it, but it's stocks, bonds, and mutual funds, and it's gained over the years. And you may have paid a little bit of capital gains because you've held it, and you took some money out, paid for a Hawaii trip or whatever you did. And, all those things are taken care of. And you've got beneficiaries on those, and those are fine. You get at the time of your death, you get what's called a step up in basis on that account. So what does that mean? That means that you bought it at $100,000, you got $400,000 worth of gain. If you would have pulled money out, you would have had to pay the taxes on that. So on $400,000, it's $80,000 worth of income. Okay, so you've got all these, this taxable burden. If you pass away, that burden, no longer exists because you get what's called a step up in basis. So now the account, based upon everything, that account is now worth $500,000, and there is no taxable gains, which is positive. Not so with IRAs. So say the same scenario. I put $100,000 in. It's now worth $500,000, but I put it in what's called pre-tax. So I put that money in, and that money, I got to take a tax deduction off of that money during my lifetime, during my working years. But it's grown to $500,000, and again, I've got 2 kids. I've got a spouse. If you take it out, that money is taxable, and it is taxable at ordinary income rates. So, every dollar that I pull out, is, depending upon the circumstances, depending upon how much your Social Security is, you're going to pay anywhere between, depending upon how much money you have in the IRA, it could be anywhere between 0 and 35%. So any dollar I pull out. When you pass away, you don't get the step up in basis. So anybody, your beneficiaries included, get taxed on every dollar that is pulled out of the IRA. So I have $100,000, it's $500,000. Every dollar I pull out is taxable. So I got to pay taxes, and I don't pay it at the decedent's death, at your death, at that rate. I have to pull it out based upon my current tax rate. So, maybe maybe your kids are doing well, and they have taxable income that puts them in maybe the 24% tax rate. And had you received it, or had you taken it out, maybe you were at the 12% tax rate. But because my kids inherited it, they have to pay it at their tax rate. Now it's 25%. So every dollar that you worked for during your lifetime is taxable. And here's another thing on IRAs. And a lot of people don't realize this. The more money you can pull out of an IRA while you and a spouse are alive, you're at an advantage. The tax rates. So let's use a married couple. at the 22% tax rate. So the max on that tax rate is $150,000. So if I pull out anything over, say I pull out $150,000 out of my IRA in a year. Uh, Other than diminishing all of your IRA, depending upon your circumstances, unless you got several $1,000,000 sitting in that IRA, that money is taxable, and you've got to pay that rate. What if your spouse passes away? What happens? Well, you're together. Your tax rate's at 22% at the $150,000 mark. Now you pass away. Now it drops down to $75,000. So at $75,000, you got to start paying the single rate taxes. A lot of people don't think about that, and that could be a huge hit, especially if you have to pull money out of an IRA. If we set up your beneficiaries to, and this has been the common thread, because we want to take care of our spouse. A husband walks in and says, "Hey, I want to take care of my spouse. I got $1,000,000 sitting in my IRA. My wife needs to inherit the full $1,000,000." I look over, I look at how much they spend on a monthly or yearly basis, and I'm like, they don't even touch any of that $1,000,000, or maybe they're touching very little of it. And now um, they've got RMDs. RMDs is required minimum distributions. So it's an amount that you're required to pull out on a regular basis. So now you're at a single rate. So I designated say I designated my spouse as my beneficiary on my IRA, and now she's required to pull out money based upon her life expectancy. And because we designated your spouse as the full beneficiary, that may throw her into a huge tax bracket, because she's required to pull out a certain amount of money. And depending upon the age, say she's 80, and she's got to pull 1/20th of the value of your estate. Well, out of your IRA, that's $1,000,000. So 1/20th is $50,000. So she's got to report or take out $50,000. Then she's got Social Security, so maybe she's receiving $18,000 in Social Security. So some of your Social Security is going to be taxed. Now getting at that $68,000 level, we're not even talking about annuities or any other income or pensions or anything else that may arise, and you're very quickly into the 22 to 24% tax bracket. And that's not including what the state is. So if it's retirement income, the state of Illinois, we're not as concerned because right now that is not taxed. But our great state of Illinois is broke, so how long will that last? Who knows? That's beyond this discussion here. But it's taxable. So every dollar pulled out of that account is taxable, and it's definitely going to cause issues for your spouse. The other issue, naming beneficiaries, and I'm seeing this more and more because it's becoming more and more prevalent, where a lot of people have a large portion of their estate in IRAs. State of Illinois, there's a cutoff of $4,000,000. So if you've got an estate over $4,000,000, we would have to do some tax planning, because every dollar above that $4,000,000 is taxable. So not only do you have to pay taxes on the IRA, but you also have to pay taxes because it's an estate tax. So if we're getting close to that $4 million mark as a joint couple, there's some planning that needs to be made and can be made. But what are the other issues associated with it? So we talked about estate tax. The other part of the estate tax is federal. If you've got $11 million in your IRA or $11 million, there's an estate tax issue. But a lot of people I talk to, wish they had $11 million. In all reality, that's very far and few between. But $4 million is getting closer and closer every day. There's a lot more people that are getting close to that $4 million mark. There's a taxable issue. Well, taxable issues don't help us deal with that if we use beneficiaries, because it sets up an estate tax. So if I have a somebody with $4 million, and I can set things up and move some money out of the estate, or put money off to the side, and utilize both exemptions of a family member. So husband and spouse, I can utilize up to $8 million in to protect the assets. But again, that's an issue that can be addressed and may not be an issue for our listening audience. But if it is, come talk to me or call me. You're welcome to call me at any point in time during this broadcast at 618-217-1400. Again, it's 618-217-1400. Love to talk to you about your issues with regards to beneficiaries and IRAs. Let's help you through, navigate this transition period with regards to your estate plan. Here's the other issue with IRAs. Before January 1st of 2020, so right before COVID, our federal legislators passed a bill called the Secure Act. In the Secure Act, it says that if you have a situation where you're giving money to your beneficiaries, those beneficiaries have to, not it, there's no ifs, ands, or buts. They have to remove all the money within 10 years. There's a couple other rules that may shrink that, but if it's a 10, but if it's a spouse, that doesn't apply still, unless you really married young, and there's more than 10 years difference between you and your spouse, then the 10-year rule does apply. But other than that, there may be some other issues, associated with it. So, we definitely don't want you to necessarily always give it to your spouse, but there's a 10-year rule, and in this 10-year, you've got the beneficiary has to pull that money out. So again, let's use Anna and Jeremy as an example. So Anna and Jeremy are to receive this. Say it's $1 million. So in the $1 million, each one of them have to receive, or spouse has already passed away. They are receiving this $1 million. It's now each one receives $500,000. So each one of them has $500,000 of taxable money. They have to pull it out in 10 years. So what happens to that? So they have to pull it out in 10 years. That means that it's going to be a $50,000 per year money that they're going to pull out of this IRA. And that doesn't even include if the money continues to grow and interest continues to grow. So you're left with So that's $50,000 a year. Well, if it's a family of, husband and wife, and maybe they're making $150,000, and you just threw $50,000 on top of that, well, now that money is taxable, and it's at a significant higher tax rate. So, doing some pre-planning is, will be helpful to deal with that issue with regards to how do we solve that issue. And of course, minors giving $500,000 to a minor is definitely going to be become an issue. There's definitely this 10-year rule. It's going to impact a lot of people. Not a lot of people know about it. If you want to find out more about that issue, or anything with regards to beneficiaries, or how to solve this problem with regards to beneficiaries, you're welcome to call us at 618-217-1400. Again, 618-217-1400. Again, got to give a shout out to all of our sponsors. It's so important for them to be supported and help them out. Between Bridges Home Realty, Keystone Places at Magnolia Commons, we really appreciate their support, and we hope that you can help support them. Bridges Home Realty, it's your go-to destination for seamless and integrated home buying experience. They specialize in buying and selling homes and offer expert living placement assistance. For more information on Bridges Home Realty, visit www.bridgeshomerealty.com or call them at 618-830-6565. Again, 618-830-6565. And for Keystone Place at Magnolia Commons, they have a beautiful facility that they're building in Edwardsville, and it is fantastic. Go take a look and take a tour, check them out, see if that's a good place for you. Keystone Place at Magnolia Commons, they have a great facility, great food. It is not your mom and dad's, what is thought of as a nursing home, or the assisted living, or I mean, some places you walk in and you can smell that it's a terrible place. And this place is gorgeous. It is fun, upbeat, lots of activities, and lots of plans associated with this. Call them, check them out. They are located in Edwardsville, but call them at 618-685-2259. Again, it's 618-685-2259. Again, we thank you for joining us today on Let the Record Show. I hope you found our discussions on beneficiary designations both empowering and enlightening. And remember, at Civia Law, we are here to guide you through life's transitions. No matter how complex they may seem, we are here to help. If today's show has inspired you to take action, secure your future, don't hesitate. Reach out and call the radio show at 618-217-1400, or email us at radio@civialaw.com. And it's S as in Sam, I, V as in Victor, IA, law.com. As a special offer for you, dedicated listeners, the first 5 callers that call, whether it's today, Monday, and you mentioned this radio broadcast, will they will you'll receive 30-minute complimentary consultation with our experienced team, valued at over $150. Stay tuned for more episodes as we continue to explore topics that matter most to you. And if you have any suggestions, please don't hesitate to call us. I love suggestions. I want this to be a great program for you. So give us a call at 618-217-1400. We will definitely listen to all comments, and we want to make this a great program for you. Till next time, take care, and remember, your future is in your hands. Let the record show that we're here to help you every step of the way. Thanks, guys, and I look forward to hearing from you and talking to you in the future.